Good evening, everyone, and welcome to our seminar on parental alienation. I'm Ed Elliott. I'll be your chair this evening. Thank you all very much for coming. The plan this evening is we're going to hear, first of all, from Jennifer, who's going to talk to us a bit about definitions. Stephen's going to talk to us about the latest, I think, developments in the law, the more recent case law, and Rachel's going to focus more on remedies. I think from all of our speakers, you're going to hear from their experience about how you deal with this issue in practice, how we should approach the different stages of litigation, things that you might try and break the logjam that often exists in these cases. And then when we've done that, we'll hopefully have some time for questions. As some of you may know, I also sit part-time as a DDJ, so I've got one or two things that I think I'd like to flag up from a point of view of looking at this from the bench, which might be helpful. And we'll deal, as I say, with any questions or points that arise. But before we get into things, there are various notices that I'm always told I need to mention. So very importantly, in the event of any fire emergency, please follow the fire exit signs to the nearest exit and walk to the assembly point, which is across the road by the gates to Lincoln's Inn Fields. The doors will automatically release if the fire bell rings. Very, very important. The other thing to say is that this event is being recorded. So the recording will be uploaded to our YouTube channel. And the links and the slides will be sent to all of you following the conclusion of the event. And then after we have finished, there will be food and drinks downstairs in our pub, which is back down the stairs, and then round to the left, kind of that way, but just follow where everyone else is going. And we'll obviously be very pleased to speak to you down there afterwards. Right, so our first speaker is Jennifer Grehan. And I think in your packs you will have short biographies for all of us, and I could read through that. But I always feel that perhaps something a little bit more human is slightly more interesting. So I've asked our speakers for a fun fact about themselves, and they struggled to think of anything. But it transpires, after Jennifer told me very clearly that she was no fun, that when she started life as barrister, she decided that she would go and do her pupillage in Devon so she could go surfing. So she purchased 2 surfboards and off she went. However, she tells me, due to the busy life that we all lead, she went surfing once. But there we go. So without further ado, I hand you over to Jennifer.
Thank you, Ed, and evening, everybody. So, yes, I'm going to talk a bit about the definition and then go on to checklists. Those are the ones provided by CAFCAS, and hopefully what else I'll do is I'll just set out some preliminary issues that might arise during these kinds of cases. I act equally for resident and non-resident parents, so I very much hope even the introduction aspect of the seminar is helpful in both of those, regardless of whether you're representing the resident or the non-resident. I'm starting with the definition. So we use the CAFCAS definition, of course, because they would ordinarily most often be involved in these kind of cases. The CAFCAS definition at the moment on their website is that there is no single definition. And actually that's changed. I don't know quite when that did change, but there once was a specific definition from CAFCAS, and it was quite short and concise. You'll see now in this paragraph that they have on the slide, it's longer. And as I said, they said with no single definition. They've also set out in that paragraph that behaviours can result from a parent's feelings or unresolved anger, and that behaviour of a parent can be conscious or subconscious behaviour. And I think that that's very important to note. Something else, of course, that we will all be aware of when we deal with these cases is that the allegation of parental alienation is often involved in cases where there also has been allegations of domestic abuse. And what that does entail is, before you even go into the allegations of parental alienation, the court will almost certainly always need to explore the allegations of domestic abuse, and CAFCAS are very clear from their website. The first step in assessing the reasons for the child's resistance or rejection of the parent is to consider whether domestic abuse or other forms of harmful parenting are factors. And they go on to say that they have to distinguish between harmful conflicts, domestic abuse versus bond breaking and alienating behaviours. What we know, and Rachel will talk more later about domestic abuse in this context. But of course, what we do know from Practice Direction 12J is that children, by virtue of being exposed to domestic abuse, are in fact victims of the domestic abuse themselves. In terms of the CAFCAS behaviours checklist, so if you go to their website on CAFCAS, they have documents that you can download. They are Word documents, and it's almost a checklist. It's actually for the CAFCAS practitioners themselves to use when they're assessing cases. And we can all download them and we can all look at them. I actually haven't put every single one of the criteria on my slide. What you can see in front of you is just, I've just captured some of what I would say are the more significant and obvious aspects. You'll see from the top, and I've highlighted it, it says, the child's opinion of the parent is unjustifiably one-sided, and it can be all good or all bad. And then I just wanted to go down to where I've underlined, so it's the fourth point. So reactions and perceptions are unjustified or disproportionate to a parent's behaviours. And CAFCAS have gone on to say this is often based around a single incident or alleged incident. And I just highlight this to say CAFCAS are aware that there could well have been an incident. That doesn't necessarily follow, though, that hasn't been behaviours by the resident parent to alienate the child. So CAFCAS will be wanting to see that the child's response is proportionate to the incident. And just one of the important criteria, and I just wanted to point out, was the below one, which says revises, so that's the child revises history to eliminate or diminish the positive memories of the previous beneficial experiences with the rejected parents. And that's very important for us always to be aware of and to point out, because it's a very strong point, particularly where we're talking about an older child who lived, or not necessarily, but spent good time with a parent and it was positive. Something's happened which isn't quite ascertainable, and then the child is rejecting that parent. So that's always something that as practitioners in this field we do need to be alive to. This page, again, this is on the CAFCAS website. It's in the same document. This checklist is a list of the behaviours. Again, it's just an example. It's not exhaustive of every single behaviour that can be demonstrated by a parent that CAFCAS will say was alienating a child. This is just an example. I think that this list is so helpful. CAFCAS use this in their assessment of parents and children when they're assessing this particular idea of alienation. Actually, what I have used this list for before is when I was representing a resident parent, and when I was involved in the proceedings, it wasn't necessarily a live issue, but it became obvious to me that there may that my own client may have been displaying some of these behaviours. And so what this document allowed me to do was put it to my client and go through this checklist to say, this is what CAFCAS, who the court view as an expert, say are behaviours that are worrying to the court. So I think that this document, this checklist, can be helpful in many situations for both the resident and the non-resident parents to just be reminded of something they may think it's harmless, but I think that's very helpful for us as practitioners. And I've just put in the bottom there, so Lord Justice Jackson said, the manipulation of the child need not be malicious or even deliberate. But it's the process that matters, not the motive. Again, very, very important. May well be that a parent's not even conscious of the behaviour that's displayed. Something that's not on that list and I need to talk about, it may well be talked about later on in the seminar. A parent may never say a word, the resident parent may never say a word to the child, but actually what they can do is they can instill fear. And what that can look like in reality is that the child might say the other parent's name. They will get a response just without words from that other parent, which shows that child that to say the parent's name or the other caregiver's name, not welcome in the house, not to be spoken about again. Of course, that may only need to even happen on one occasion. Obviously, those occasions will be much more difficult to use the checklist and identify the behaviours on behalf of the parent. So what you would do in those cases is you would look more to the checklist for the child to establish the behaviours from that point of view. I'm just going to talk briefly about this case. This is Mr. Justice Headley in Re. This is obviously one of the more popular cases that people refer to in parental alienation cases. And what he said is, it's going to be mentioned again, you'll probably hear it a lot, but he says it's really important that the parties at a relatively early stage have an opportunity to give evidence, not against each other, so not necessarily against each other, as happens in fact-finding hearings, but in respect of the interests of the child. And that I would say is particularly important, and you can do where there's no allegations of domestic abuse. Obviously, it's different if there's domestic abuse allegations. The court will want to establish a factual matrix essentially to work from. But without that, you should be asking the court, let's have evidence as soon as possible so we can see from both parents' point of view the view is of the relationship with the child. He also goes on to talk about judicial continuity, and I'm but I think this paragraph is really interesting, and he talks about a case being transferred to the High Court, and he essentially says if the case is to be transferred to the High Court, it seems to me it's desirable that the judge so considering the matter consults with the Family Division Liaison Judge, and that the matter should be transferred. And he says, not absolutely, but all directions with a view to the High Court judge considering whether the matter should remain in the High Court. And he goes on to say what it allows to happen in the case is for a fresh pair of eyes to be put on the case. The High Court could set some directions in the matter, and then it could transfer the matter back to the previously allocated. That judicial continuity to continue. But I think that can be important for us all to point out that it may well be in some serious and complex cases that it can be transferred to the High Court for that fresh pair of eyes. I've just put a few notes down here in respect of the preliminary, what we can do at the beginning. Timetabling weeks, not months. I think sadly we all know it will never be weeks, and it will be months. I don't want to say how many months on average, but the reality is we should still absolutely be saying that, and it still should always be recorded, you know, as parties' positions on the basis of an order. Again, judicial continuity, all of the relevant cases, and also I put Re M here, so this is Justice Hall, he's and he goes on to refer to Mr. Justice Mumby in Re D, and he talks about those supported he supports Mr. Justice Mumby saying consistency of judicial approach, and he also talks about there being a strategy for the case, and judicial continuity allows some kind of strategy at the outset of the case. And what he describes that is, he says, part of a wider plan for the children. And I think that's very important, and certainly that could only be done where there is some judicial continuity. Again, an early fact finding, but of course, if it's domestic, well, allegations of domestic abuse involved, that can take some time, as we know, not least due to the court being able to list matters, particularly ones that go on for days. What I did say, what I've said underneath the report, disclosure as early as possible. If it seems like it's going to be a fact finding, even before it's listed, you should be asking the court and saying it's going to be likely there'll need to be evidence on this, and the court will see all of the relevant evidence. And obviously we know police and hospital records can take a long time, so ask for that as soon as possible, because you certainly wouldn't want to be delaying your case because disclosure wasn't in. But of course we know that that happens often. I'm not going to talk about experts. You'll hear from Stephen shortly on experts. And then I just wanted to say it's never too late to raise parental alienation. Actually, what happens in a lot of cases is it's not really obvious to anybody, even the parents, because proceedings are going along. If there's not a guardian involved, the court won't necessarily know what the child is saying. They'll just hear it from the resident parent, maybe perhaps hear some things from the non-resident parent. And it won't be till you have your Section 7 report that the CAFCAS officer will come back and say, tried to do my best, tried to have a talk, and nothing. And in effect, you're towards the end, you're towards what would ordinarily be the end of proceedings. It's not too late because it might only come up then. So don't worry about saying, yes, we've been in court months, judge. But this is what I'm saying now, because this is the cases. If we just look at point C here, so obviously this is rule 16.4, one of the criterion, where there is an intractable dispute over residence or contact, including where all contact has ceased, or where there is an irrational but implacable hostility to contact, or where the child may be suffering harm associated with the contact dispute. That's where we should all be raising and asking the court to appoint a guardian in these cases. Section 37 reports. Again, this is going to be addressed later, so I'll just touch on it briefly. One of the important things I wanted to say about, two important things about Section 37 reports in these kind of proceedings, in private law proceedings. That case, Re-H, the court found that that social worker had no good experience of parental alienation, and therefore the court couldn't place any weight on the local authority's view of the situation. That's just something to be mindful of. If you do have a Section 37 report and it doesn't seem right to you, you should be referring to that case. It's a question that you need to be asking the social worker who's given the evidence on behalf of the local authority. And then just to say, Mrs. Justice Baker in Re-S made a point in those proceedings of saying it was difficult for local authorities. They do a complex care cases, but in fact it's quite difficult often for them to get a grip of the complex matters in private law proceedings, because it's not what they do, and it can often be difficult when they see it as a private law dispute between parents and a significant harm threshold hasn't been reached. But of course we know that's not necessarily the case, because if the child is being harmed by not being able to have a relationship, then that constitutes as significant harm. Local authority should have much. In respect of orders, this is not even just in parental alienation cases, in all children contact cases, the order needs to be very clear. I've had so many orders over time that place the onus of responsibility to present themselves in contact on the children, on the child or the children, and that's the way that it could be worded. The child must have contact. I've even had an order that say the solicitor, after a final hearing, the final order said a solicitor must arrange the contact, who of course doesn't have any funding anymore. So just make sure that orders are very clear. The resident parent, they are ordered to facilitate that contact and to make that child available. Where it's not appropriate and the court just cannot order contact, maybe even not indirect contact, or even if there is indirect contact, you need to look at the case of RECU. The court allowed a direction for the child to have therapy. You can but ask if you're representing the non-resident parent, it would be helpful if they could offer to pay for such therapy. But of course, there are avenues that are limited, but there are resources where a child could go and get therapy. It's very much something that you can do at the outset of the case. Doesn't mean that there needs to have been finding for parental alienation. It's something that both parents should be encouraged to work to for the sake of the child if there's an issue with contact with the other. I've put this case in, Create. I think that it's great what the court said in this case, and I use it all the time. And so I'm going to read the quote verbatim. So the court said, but what one can reasonably demand, not merely as a matter of law, but also and much more fundamentally as a matter of natural parental obligation, is that the parent, by argument, persuasion, cajolement, blandishments, inducements, sanctions, for example, grounding or the confiscation of mobile phones, computers, or other electronic commitments, or threats falling short of brute force, or by a combination of them, does their level best to ensure compliance. This is what one would expect of a parent whose rebellious teenage child is foolishly refusing to do GCSEs or A-levels, or dropping out into a life of drug-fueled crime. Why should we expect any less of a parent whose rebellious teenage child is refusing to see his father? I think it's amazing, and it's so right. And obviously, you're representing, but have a parent on the other side say, "Well, I'm not going to force them," and that phrase, "I'm not going to drag them," that's on the checklist of behaviours for parents. But again, we should all be, when we're in a position where the other side, the resident parent, saying, "Oh no, I don't, why should I? It's too much." I think we should all be putting this in our position statements and making this submission about this case in court. It gets difficult, obviously, when the child is 15, 16, 17, but it's not necessary. It's not over. Obviously, we have section 9(6). You need to make good arguments to the court as to why the child should remain subject to proceedings. And on my last slide, I'll come back to why that is so important for the child, and a good list of reasons to use for the exceptional circumstances document. I'm just going to touch on Article 8 rights briefly. I know Stephen's going to talk to you some more about the late cases during his part of the presentation. I mentioned this first, the first case, so it's a Moldova case, and the parents took the matter to the European Court of Human Rights, and what the European Court of, essentially, I should have said, because they'd said the parent couldn't have no contact with their child because the case was such a disaster, essentially, and then it was just too late, as happens in these cases. And there was no future for the parent and the child, which of course is very sad. The parent took the matter to the European Court, and the court said, although the primary object of Article 8 is to protect the individual against arbitrary action by public authorities, there are, in addition, positive obligations inherent in effective respect for family life. Again, people, practitioners are not raising this issue as much as it should be raised in these kind of cases. It's very, very much an issue. Article 8 is very important in these cases where a child isn't having a relationship with one of their parents. In this particular case, as I said, very sadly, it was too late for the parent and the child. What the European Court is, they ordered the Moldovan authorities to pay compensation against the family. Not a lot of money, but again, I think it's just important to make these our courts that we appear in aware that this is an issue, and then the parent will have another route if the court doesn't do what it's supposed to do. Again, re-A, so that's a UK case, and that was an appeal. And effectively, the court had said that the family justice system in this case, as a whole, had failed to meet its duty to a 12-year-old child. And essentially, again, that was the original case was court refused what they described as an unimpeachable father direct contact with a child, refused any liberty for him to apply again. Very much a breach of Article 8. Always be putting this in position statements. And this is what I said I was just going to circle back to in terms of exceptional circumstances. I was in a case the other day. My client hasn't seen the child for over 10 years. It's incredibly sad, and it's difficult because the child's certainly been alienated. And the judge said to me, Miss Grehan, your client's just going to have to realise she can't get, the client can't get what the client wants. And I have to say, it really irritated me, because I think the court was looking at it like it was my client. It was just what she wanted. The child was over there. It's just all about my client having some selfish need to see the child. And it bothered me because nobody, including the guardian in this case, had any, there was no analysis of the child on how this would affect children. So the reality is what you see, the behaviours that we see when they're children, and not even the start of the problems that the child can face as it goes into adolescence and also into adulthood. So very much so, always be reminded in the court, it's not just about your parents, it's really important for the child. These are, so I mean, also, this list is what the court will be looking at, and this is what it's aware of in terms of how the long-term issues associated with rejection of an attachment figure. So low self-esteem, lack of trust, depression, drug and alcohol problems, divorce, shame, excessive guilt, and adult dissociation, and really most importantly, high levels of identity diffusion. And that's something that I see crop up in these cases all the time. So again, reminds the court about this, not just about your client. It's really important because in fact, it's going to have an effect on the child for the rest of his or her life. And that is my part of the seminar. That was a useful introductory.
Right, Jennifer, thank you very much. I, sharing this, have managed to get away, obviously, without having to prepare slides. So for me, it's very interesting to hear what my colleagues have been working very hard on, and I think some thought-provoking things for all of us. One of the things that I spotted was, I think it was in Re-E, that use of the term in judicial strategy. I had somebody in front of me from the other court not that long ago, and he kept going on about that you've got to have a judicial strategy. And I thought it was so clever. You did it from Mr. Justice Headley, and I have no idea. There we go. Just one thing I think before we, well, two things actually before we move on, I wanted to say is I entirely agree with what Jennifer has said about therapy, because whilst for adults that is a process, you can't force the parents to go to therapy. I've certainly had cases where I have been sitting, or cases where I have been appearing, where judges are very clear that in the same way you can make specific issue orders about other things, you can order the parents to make sure that the children engage in therapy. That is something I think that is very important to remember. And I was going to mention one other case before I hand over to Stephen that I've always found very helpful on this idea of the human rights angle. And that's a case called Re-C, which is from 2011. Those of you that've got a pen, it's two family law reports at page 912. And it's handy because it's a Mumby judgment, not when he was president, but before that, when he was in the Court of Appeal, but nonetheless has force coming, I think, from somebody who went on to head the family division. And what he said was this, it's paragraph 47. I do not propose to add to the jurisprudence or to attempt to state in my own words what has already been so clearly said by others. All I need do is to extract from the case law to which I have referred the propositions on which Mr. Scott Manderson places particular reliance. And here we have the important bits. So number one, contact between a parent and child is a fundamental element of family life and is almost always in the interests of the child. Contact between parent and child is to be terminated only in exceptional circumstances where there are cogent reasons for doing so and where there is no alternative. Contact is to be terminated only if it will be detrimental to the child's welfare. And then three, this one I think is particularly important if you are getting from the court, oh, this has been going on for so long, we've got to bring this to an end. Three, there is a positive obligation on the state and therefore on the judge to take measures to maintain and to reconstitute the relationship between parent and child, in short, to maintain or restore contact. The judge has a positive duty to attempt to promote contact. The judge must grapple with all the available alternatives before abandoning hope of achieving some contact. He must be careful not to come to a premature decision. Contact is to be stopped only as a last resort and only once it has become clear that the child will not benefit from continuing the attempt. Four, the court should take both a medium-term and long-term view and not accord excessive weight to what appear likely to be short-term or transient problems. Five, the key question which requires strictest scrutiny is whether the judge has taken all necessary steps to facilitate contact as can reasonably be demanded in the circumstances of the particular case. And six, all that said, at the end of the day, the welfare of the child is paramount. The child's interest must have precedent over any other consideration. So, as I say, I always rely on that one, which I think has some very important principles. Now, Stephen. Now, I haven't asked Stephen for a fun fact, partly because I've known Stephen for a very long time, but also because when I was looking on his profile, I came across a quote that is at the top from Chambers UK from 2023. And I'm not going to read it all, but it concludes with, he's a fierce, formidable opponent in the most joyous way. I don't know what that means, but it may be that during the course of the next 15 minutes, Stephen will tell us. Thank you very much.
Right, I'm going to put my timer on because I find that at the beginning of cross-examination, when the judge tells me I have 15, 20 minutes, it helps me stay focused. So thank you all very much for being here. My part of the talk is to talk about the case law and to look at tips. And the first case I wanted to talk to you about is Re-C. So it's a 2023 case. And the main point I wanted to raise in respect of key principles is that parental alienation is not a diagnosis that's going to be made by a psychologist. It is, just like in lots of ways, an allegation of domestic abuse as it pertains to physical, sexual, emotional, psychological, coercive controlling behavior. It is a matter of fact that the court needs to determine and not something that a psychologist can rock up and diagnose. So in that way, the court can't obfuscate its duty to really get its hands dirty in respect of the issues. So to be clear, parental alienation is not a syndrome capable of being diagnosed. It's about the court taking a really robust and forensic approach to the alienating behaviors. It's a question of fact. And again, I draw the parallel between if there's a disputed fact between the parents, in a for Hydra, the court has to remember that Kafkas is not an arbiter of fact. That's for the court to deal with. Again, Re-C goes on to really get judges to focus on the particular behavior that's been found to have taken place within the family. And again, that's a finding made by the court. And it talks about the alienating behavior, which when we think about the precedents in respect of coercive and controlling behavior and talking about patterns of behavior, we can make an analogy with parental alienation behavior. But really the takeaway that I want us to think about is the court is focused on substance of the behavior. What has gone on? It's about the pattern rather than the label itself. So when thinking about constructing a schedule of allegations, think about, we're often used to putting together those schedules of allegations with respect to coercive controlling behavior. Think about developing a story when putting together a schedule in respect of parental alienation. So I feel slightly pressured because Jennifer kept saying, Stephen's going to talk about this, Stephen's going to talk about that. So I'm really hoping that I do cover the matters that Stephen's supposed to talk about. But one of the things I did want to be clear about is that what was happening in the family courts is that people who were technically qualified psychologists were rocking up, doing reports, effectively brandishing one parent or t'other with a label of parental alienation. And then it turns out that that so-called expert was not registered with the HCPC and was not registered as a chartered individual with the British Psychological Society. So the challenge for the judges and the lawyers is really taking a keen eye at the CV of an individual before an instruction takes place, even if it's an agreed instruction. Really look at, is this individual registered HCPC or the British Psychological Society? That is a baseline, effectively, that the court wants you to work from going forward. The court is saying, look, we can't stop people holding themselves out as psychologists. We can't stop people referring to a piece of evidence as expert evidence. What we can say is that, effectively, it's good practice if the judge effectively wants to endorse an expert put forward by the other side that's not registered in the two ways that I've described, you have to say to them, Reece says, judge, you need to give a specific judgment as to why you are making an active case management decision to allow this expert to be instructed. And that may make the judge say, oh, I can't bother to do a judgment, so why don't we get someone that's properly registered? Yes, that's another case. That case was about a cult, and the facts of it are salacious and interesting, but really some of the takeaways that I want us to think about is that the court again is focused on the behavior and whether or not the behavior itself is abusive. And Sir Andrew McFarlane has said that it needs to be considered that it doesn't matter whether the behavior is derived from a syndrome or a diagnosed condition. It's about looking at one, what the pattern of behavior is, and what has been the impact on the child, one, in terms of their own identity, and two, in terms of their view of the other parent. So one of the things that came to mind when Jennifer was speaking about Kafka's definition of parental alienation, it's a point I often raise on behalf of parents in court, because I think it really, when the court takes a step back, has a ring of truth and it's quite a powerful point. A child is ultimately, in terms of their identity, who they are. Think about it from a perspective of a child being mixed race, half black, half Chinese. How they see themselves in terms of their cultural heritage. 50% black, 50% Chinese. That's how they understand who they are in the craziness of the universe. So apply that to this. If the child is working from a false understanding about who one of their parents is, and they're persuaded that their mother or their father has abused them physically or sexually, and they're formulating their identity of who they are. Who am I? When they look in the mirror, who am I? When I think about myself, am I descended from that monster? Because if I'm descended from that monster, I'm really worried that maybe I'm 50% monster. And that's really key in terms of looking at and taking the issue of what's in the child's best interest back to what the impression of the non-resident parent is. So it's another avenue for bringing the case back to what's in the child's best interests. And again, all the matters that Jennifer beautifully articulated in respect of first principles as to the fallout for a child if they don't have a relationship with a non-resident parent. But again, all the research identifies that if a child has a positive relationship with both parents, that child is more balanced, more well-rounded, they go on to have better relationships themselves, they have a better engagement with education statistically, and they have better outcomes. I've been clicking away at my laptop, but not at you. So I think we are now back together. Hello. So I'm still in Cultland, and the facts of that case were quite interesting. This mother was basically hoodwinked into being involved in this cult that was Australian-based, and she promised many, many judges that she would extricate herself from it. And the father said, look, I'm going to get prohibited steps orders, with specific issue orders for this child not to be negatively influenced by the cult, because the cult had some quite bizarre views on things, and it wasn't healthy, and that was the finding of the cult was not in the child's best interest to be influenced. So the court's powers of what they can do if they have made a finding of parental alienation, as was found in this case as a matter of fact, they're set out in sections 11A to 11O of the Children Act. But what's key for me, my main takeaway was, we often talk about what is an issue of last resort. If we're in care proceedings, we talk about adoption being a matter of last resort. We talk about all the REBS analysis, and it's a matter of last resort, it's draconian order. And if your opponent comes to court and says, oh, you can't possibly change where this child lives, it's a child's main home, they're going to have a longer commute to school, and they've got friends and their clubs, it would be simply disproportionate to change residence. And I'm going to ask DDJ Elliott to tell you all about when he did change residence on one occasion. But Sir Andrew McFarlane says, in cases of parental alienation where there is such a finding, a change of what we used to call residence, obviously where the child lives, is not regarded as a last resort. And so you should be, I've in other cases where parental alienation has been at play, effectively the threat in and of itself meant that contact was able to progress, because it's quite a powerful threat. So it's worth having that in mind in your arsenal. So next slide. Jennifer quite properly highlighted what the European Court has said in respect of the court's duties in terms of Article 8, because it's not just the parents whose Article 8 rights are breached when contact doesn't take place, but it's the child's Article 8 rights. So there's a duty of exceptional diligence. And it's often said, well, you know, contact hasn't taken place for 2.5 years, and so we need to take it nice and slow. When that's really difficult, because when you're fighting a status quo, if that status quo has been created by a behavior and a pattern of parental alienation, well, what you want to do is cut through that and maybe have a quicker staged reintroduction in line with some resources that I'm going to refer to in another slide, but they need to think outside the box. It's not just about the bog standard, well, we'll have 4 weeks of indirect video, and then we'll have 2 months of this, and then 4 months of that. No, you need to say the passage of time in and of itself will create a de facto determination of the matter, which will not be in the child's best interests. So they need to get on with it. It talks about, look, courts are really busy, judges are overworked, especially district judges, and it's often the line of least resistance when the judicial system just says, you know what, it's too stressful for the child, it's against their wishes and feelings, and it's easier just to make orders in line with what the, you know, in this particular case, the mother was comfortable with. But it really puts the onus on judges to be hard-headed and be clear with them that inaction will probably reinforce the position of the stronger party. And in that case, a stronger party is the person creating the false narrative at the expense of the weaker party. because it's very difficult for the non-resident parent to say, no, I'm great, I love you, I did actually send you presents for the last 5 years, but you haven't been given any of them, so how would you know that I care about you? And actually, that reminds me, I did this case in Milton Keynes recently. I was for a dad. He works in Tesco and he's neurodiverse. He had never met his child. The child was 8. He had been in private law proceedings for 5 years. Yeah, 5 years. He had been paying child maintenance, having never met this child, 7 years. And at the case management hearing, the circuit judge said, oh, very calmly looked at all of us and said, oh, well, Mrs. Lee, when's the last time your client saw this child? And I nearly lost it. And I said, my client has never met his child. That is why we are here. He's been paying child maintenance for 7 years. And then the social worker had taken a video of the child literally running up to the father, hugging him, completely different to what the mother had described him to be. And the judge cried in court. And I'm not going to say because it's been recorded. But anyway, it was a lovely judge in Milton Keynes who was very emotional. And he said, you've made this job worthwhile because you've shown me, you've been really committed to this child. And he actually apologized. He apologized to the father. And he said, it's taken care proceedings and the private law system failed you, and I'm sorry on behalf of the justice system. And on the basis that I didn't really feel like going to Milton Keynes that day, I was quite pleased I got out there. So we move. Yes, talks about court must therefore be alert to the early signs of alienation, and it will amount to effective action will be a matter of judgment, but it is emphatically not necessary to wait for serious, worse still, irreparable harm be done before appropriate action is taken. And one of the things that happened to me today in Slough Magistrates Court was that we were trying to persuade the bench, it's an agreed position, that they needed to put this matter up. And I gave them a 9-page position statement about the disclosure from the health visitor, the police, the GP, the social services section 737 report, all reasons making it really clear. We're very grateful to you for your time. But we think that it would be better for the children to have judicial continuity and put it up. So I'm flagging here on this slide that parental alienation is a reason to persuade magistrates, because many of our private law cases start in the magistrates. Say to them, this should be transferred to the DJ for the normal reasons that you're told that you shouldn't be dealing with it, but because this is parental alienation, and can we please be before a Section 9 judge? And if not, we'll write to them ourselves. So I put together, just from life, but also from reading the case law that I have looked at, things that I don't say is, a comprehensive list of all the things that can be utilized in these types of cases, but seem to me to be a good checklist to engage with at an early stage when faced with a parental alienation case. So first of all, as Jennifer said, get your fact-finding in early, get the relevant disclosure, and some of that disclosure might be really nuanced, but it's important to try and get it. Ordering an ISW to undertake direct work with the parent and the child, including the ability and permission for that ISW, independent social worker, to facilitate contact, especially if the resident parent is saying, oh, contact couldn't possibly happen. And what is a good way around that is simply just saying, if the independent social worker recommends that they would like to observe some contact, then that is a way around the resident parent agreeing to it. So do we need to get the local authority involved early on? So Section 47 investigation, can there be contact that takes place at school or the nursery? Because in a couple of private law cases recently, I've had the father undertake not to remove the child from the nursery, but there has been an agreement that when the mother is not present, the father can attend nursery events. So it's another way for him to build rapport with parts of the nursery. He's got parental responsibility. It's a safe environment. Jennifer's right, appoint a guardian, and also go old school, think about appointing NIAS, just another avenue in case CAFCAS is really busy. Elliott very kindly identified when thinking about the intensive family therapy that's available to parents or children is, and it's not on this slide, but I've got others that I'll circulate. If you make a note of it, it's a resource called the familyseparationclinic.com. And effectively, certainly a lot of my private law cases, if they've got a bit of cash, then it's useful to use this as a resource. And if you think about it from the resident parent's perspective, it means that they're less likely to be criticised if they engage with it. In the war story I'm going to tell you later, there was a psychological report on both parents. And so think about, does there need to be a global family psychological assessment, looking at the entrenched views, wishes and feelings of the children, as well as the psychological functioning of parents. Unfortunately, in the war story I'm going to tell you, my client didn't come out too well in that report. So we try to ensure judicial continuity. Again, we think about the strategy for a case, what that might properly involve. That can involve a strategy about imprisonment for the purposes of deterrence or coercion. I know that DDJ Elliott has often sent me an email saying, can I borrow your robes? I've got a committal that I need to go to, which often makes me think, oh gosh, someone's got a case management plan to use imprisonment as a tool to get parents to function. And Jennifer's point about timetabling in terms of weeks rather than months, and we've talked about intensive family therapy. So another case is called Re-GB, and I'm going to try and wrap up. I've got 2 minutes left. It's just another recent 2023 case where the courts reiterate, for the avoidance of doubt, it's not for a psychologist to make a finding of fact that a parent is responsible for parental alienation. That is for the courts. So I'm going to squeeze along. 1, 2, 3. Okay, Re-A, you can all read, so I'll let you read that in your leisure. But effectively, this was a bit more of a nuanced case where the mother wasn't at fault, and the court acted on the teenager's wish, effectively not to see the father. And this effectively goes back to Jennifer's point and her quote about, yeah, okay, wishes and feelings are important, but effectively the court taking this case by the scruff of the neck and says, most of the time, a child's wishes and feelings will be determinative. And of course, the weight given to those wishes and feelings will increase proportionately to their age, maturity, understanding, all the things we know, but just not this case, because this child needs to see their father. Bear in mind, of course, we talked to you about human rights violations and how that might be a breach if there's a refusal of direct contact. And I want to be clear that when we talk about a no contact order in private law proceedings, for those of us who do private law and care, we need to think about the arguments that we make when we're making arguments against an adoption order. What do we say? Re-BS, option of last resort. Re-C now says, in terms of the ICO judgment, what available resources can be put in place before separation takes place. And if you think about it, if you're not in care proceedings and you're never going to be in care proceedings, what is the equivalent in private law of your child being adopted? It's a no contact order. It's effectively a draconian order. And therefore, in certain circumstances, you should be saying it's a draconian order. It should be an order of last resort. And I loved what Ed said in terms of the 2011 authority, because it puts the onus on the state, aka the court, who obviously have to act in compliance with human rights, with the Human Rights Act, to think about what other resources are available. And those resources are going to be set up by Rachel Schon, my learned friend to my left. But I wanted to highlight this case because it's recent. It's by a High Court judge, Livian J. It's important, but the way I'm flagging it with you is that effectively I'm describing it as the pendulum swinging back. in terms of wishes and feelings. Because what Livy and Jay says is that children are autonomous, they have their own feelings and perceptions, particularly as they become older, and they wish those to be asserted within their own personalities. But I pause there to say, what needs to be really mindful for how one's identity is formed, how one's feelings and perceptions are formed. I used to think that basically I could mind read my mum when I was 5, because she didn't need to tell me anything. She could be in the room next door and I'll tell you how she's feeling, what's going on for her. Such is the level of the intuitive bond between a child and their primary carer. And so the court needs to be really clear that, yeah, I get it. You have entrenched, clear, genuine perceptions and views about your non-resident parent. I just don't think they're necessarily yours. What she says is that the parental alienation label has been thoroughly unhelpful in this particular case. It's embedded conflict and a sense of one parent being right and justified while the other parent was wrong. And so if you're for the resident parent, you need to be using this authority. You need to be saying, nothing to see here. Yeah, she's a bit anxious, but look at it. She's done everything she possibly can. The wishes and feelings are what they are. No contact. The judge said the mother had allowed her anxieties and her issues with the father to influence the children. She had also been quick to abdicate responsibility, whether to them or to professionals. But this is the interesting part. And she had not actively sought to persuade the children to have contact with the father. Doesn't mean she necessarily was guilty of parental alienation, and the judge didn't find that label useful. But the nuance window, I call the nuance window because I listen to Radio 4. For those who listen to the History podcast, that'll be funny. For those who don't, so the nuance window is that in comparison to the other parental alienation cases, it's a swing back in favor of leaning on wishes and feelings, but caution should be utilized in the way that I have described. So thank you for listening. Thank you for being here. Rachel Schon has some great information to share with you. And thank you for being here.
Stephen, thank you very much. So started off, and I think I promised you Joyce, and then we got Salacious, and then he told us how he made a judge cry. So there you go. A lot to think about in that one. There are a couple of things that just occurred to me from listening to Stephen. I mean, the first is this, is that if you start looking at some of the work done by the Family Separation Clinic, they will talk about alienation in terms of an attachment trauma for children and young people. And if you have an issue where the court's saying, well, this young person is of a certain age, or should they not have respect for their wishes and feelings, that's a very good way of looking at it, that actually it's not so much about, well, the other parent's done this or the other parent's done that, but it's focusing on the harm that is being experienced by the young person and why, in fact, they need the help of the state making the attempts to work on contact, maybe the services provided, if you can find the funding, by people like Family Separation Clinic. Often, I think when I've had them, it's when things have got to a situation where maybe there's a child in need plan or a child protection plan, and the route can be about trying to prevail on your local authority to fund something that might be beyond their expertise that can actually make a difference. Certainly, I've had that in a couple of cases. Right. Now we hand over to Rachel. And Rachel has been with us in Chambers since 2019. She did her pupillage here before moving into family law. And when asked from me about a fun fact, something that goes beyond our little pen pictures, I was told, I used to work in a think tank on social innovation. Is that fun? I don't know, but maybe we'll find out. So, Rachel, over to you.
So I'm going to be speaking about the options that the court has available in terms of ways to deal with parental alienation when it comes up. And of course, the thing about family law is that every case really does turn on its facts, and it's going to be for the court to decide what is the most appropriate remedy or order in every case, and it's very hard to generalise. So I'm going to start off by talking about something called the ICFA. And interestingly, I think this is such a great option what does have available to it, but it is something that actually I've not really seen ordered in that many cases, and it's something where I sometimes think, do people know about this? It's essentially an intervention that CAFCAS carry out on behalf of the Ministry of Justice, and I think at the moment it's often other providers to do it on behalf of CAFCAS. And it's something that the court needs to order it, but CAFCAS will recommend it. And if you're representing a parent, you can obviously ask the court to specifically ask CAFCAS to look into it as part of the Section 7 report, whether an ICFA would be appropriate in this case. And what's really great about it is that it is, of course, free to parents. So when you're representing a parent who might be slipping into legal aid or generally not have much of the way of resources, this can be really helpful because it does mean that CAFCAS also work with that parent and the children to try and speak to everyone in the family, understand what the barriers are to contact, and to the extent that it's possible to work with everyone in the family to try and reduce any resistance. And then usually it will go on for a period of several weeks, maybe even months. I think, again, it's flexible. It kind of depends on the needs of the individual family. In the past, I think I've had cases where it's involved supervised contact. CAFCAS have paid for that. However, when I was having a look at the CAFCAS fact sheet on it today, they don't list that anymore as something they offer. So I'm not totally clear if it's still something that is available that they'll actually pay for supervised contact. What they will do is they'll observe supervised contact, give feedback to they do pay for stuff, yeah, and feedback to the court. So it is just a really really helpful thing to know about, and particularly when cases like the ones we've been talking about where there's a tractable dispute, this is something that it's great to have in the court's toolbox. However, obviously, sadly, sometimes something like this doesn't work, and as I said, the parents do need to be on board. It isn't going to work, and I've had cases where they've just failed, sadly. And then, of course, the court does need to think about other options. So Stephen did speak a bit earlier about transfer of residence. So I'm not going to spend too long talking about this. However, it is interesting to note that this is with the other orders I'm going to go on to. The court can order the transfer of residence or suspend it, which can be very helpful in terms of encouraging compliance by the parent who is. This is the case that Stephen mentioned. Specifically talks about how it's not a last resort, it's just a matter of applying the welfare checklist. So the court can obviously enforce a child arrangement order in the application of the other parent. And it's interesting in terms of the kind of wide variety of options that are available to when a parent does apply for enforcement. This is just taken directly from Practice Direction 12B, the Child Arrangements Programme. So again, I won't go into too much detail on this because I know we're a bit pressed for time. But it's all set out there, the options that the court has in terms of how to approach an application for enforcement in terms of what it can do, which includes getting advice from CAFCAS at that point. And then also, there's a list of the powers available to the court. So as you can see here, there's compensation for financial loss, which is quite interesting. So if one of the parents has actually lost money as a result of the other parent not complying, they can apply for compensation. There's also the option of fining the parent who's not complying, And then, of course, I suppose the kind of most draconian option, obviously, is committal to prison. And there's also the option of an enforcement order, which slightly confusingly, because obviously this is all under the heading of enforcement, an enforcement order specifically means the unpaid work order. So that's also the in terms of the unpaid work order, it's set out here in terms of what the court needs to consider before making those orders. So interestingly, the court does need to be satisfied beyond reasonable doubt that the person's failed to comply. So of course that's the criminal standard. And in addition, it needs to be sure necessary to secure compliance, and that the effect on the person is proportionate. So the court will consider things like how the impact on that person's job, things like any impact on religious obligations that person might have. So it is quite a high bar and a high threshold for making even an enforcement order for unpaid work, which obviously is less draconian than a committal order, but you're still dealing with the criminal standard of proof there. And then there's also practical matters. So there's the issue of whether or not there's actually unpaid work available in the area where the person resides. And that can be an issue because obviously that's also being there's also people in the criminal justice system who are sort of tapping into that pool. So there's a practical point there, and that's actually explicitly set out again in the statute. It's interesting as well, just the kind of actual what's set out the minimum number and maximum number. So I thought it was interesting that minimum number is 40 hours, because that is actually quite a lot of hours, really. But it set out that's the minimum. And then in terms of committal, that's obviously, as I said, the most draconian option available to the court. However, it's not something that is never used. So there was a time when it was very rarely used, and of course there's obvious issues with it, particularly where the person who's being essentially committed to prison is the carer of the child. So obviously the court is going to think about the welfare impact on the children. However, there is precedent that 1, 2 or 3 days can achieve the necessary deterrent effect without significantly impacting the children. But anybody who is applying for a committal order does need to make sure that the correct procedures have been applied with. And there's quite a helpful case, which I encourage you to look at if you are looking at making an application for committal, which sets out the procedure that needs to be followed to make sure that that is something that the court can do. Because obviously, because it's such a draconian step, all of the procedures need to be complied with, and specifically there needs to be a penal notice attached to the original order setting out that be committed to prison as a consequence of failing to comply with the order. And similarly, of course, this can be suspended, just as the order can be. So it's quite an interesting case here about the situation where children refuse to cooperate. And I know Jen mentioned a bit earlier a case which I think was also Lord Justice Mumby, as he then was in the Court of Appeal, stating that parents should essentially be able to cajole or be expected to really cajole and not force, but really kind of do everything within the realm of their parental responsibility to ensure that children do see their other parent in the same way that they, of course, are expected to make them go to school or something like that. However, that case was actually in the context of the court being asked to make a contact order in the first place, and I think the argument in that case was, oh, there's no, we shouldn't make this contact order. The mother was saying because the children aren't going to go, and that was the response. No, we can make the contact order because it's your responsibility to essentially make them go. However, it is a bit different when it's being looked at from the perspective of, should this parent go to prison because the child hasn't gone? And this was the context of this case. So what the order said was just this, that the father shall allow the mother to pick up the child, make him available, which is pretty standard wording. And what ended up happening in this case, essentially, was that the judge said, look, like, the parent has made the child available in this case, that in terms of the actual words that are on the face of the order, the parent has done that. And it was a case where the child was refusing to go. So essentially, in that case, the judge refused to send the mother to prison in that case. Well, no, it was the father actually, refused to send the father to prison because essentially the test wasn't met in terms of he'd done what was set up on the face of the order, and it didn't say on the order he needs to use every tool within his parental responsibility toolkit to make the child go to contact. So I thought it was quite interesting that difference between essentially the way it's looked at when you're looking at making the order in the first place, and then of course the kind of the last resort, or looking at how you're going to enforce that order, and even looking at the options of prison. So what's set out here is essentially the task the judge has in terms of looking at committal applications, and the fact that the judge needs to look explicitly at the language of the order. And then it's also quite interesting, there was a consideration about reasonable excuse, and there was a distinction made between reasonable excuse, where there's a good reason for the child to, well, for the parent to not comply to, for example, the child's ill, and then a case of essentially force majeure, which is not a case, not wording that normally comes up in family law cases, but if there was something that meant that it wasn't actually within the power of the parent to comply with the order because of something that's meant that it not breached because it wasn't within the power for the parent to do it. So I think that's a really interesting case, and it does of course raise questions about how to word those orders so that if you do get to that situation where you're looking to enforce an order, that it is clear enough in terms of what the parent's expected to do, that if the parent hasn't done that, it can actually be enforced in terms of either an enforcement order or committal. So I'm sitting with that in terms of how the court can navigate that issue, and perhaps our resident judge. So I think it's now time for questions. We're at 7:30. Thank you.
Rachel, thank you very much. I think again another talk packed with a lot of information and a lot to provoke some thought and possibly some discussion as well. I think for my part, there are a couple of things I'd like to pick up on. I think both Stephen and Rachel focused on, as part of the strategy, there is a difficult parent trying to take them out of the equation. So whether that's school or nursery, whether that's ICFA, whether it's making sure that your contact that you're looking for begins in a pickup that in some way does not involve the other parent, so that getting in the car, getting out of the car doesn't become a problem. And I think that is a very good tip. When we draft our orders, obviously, if we look at the current precedents, they say must make sure rather than make available. I hadn't noticed that particularly until I was on, I think, a judicial training course about a couple of years ago. And I said, oh, yeah, this case, it goes back to 2010 that says you shouldn't use that formula anymore. Really, everyone's looking pretty blankly, understanding why we did this. But it's still the case now that there are, probably all of us in this room, we think, oh yes, we can draft a contact order. And we've probably all been taught, oh, must make available. And most of us have. And yet, it's something the Court of Appeal says, well, don't do it like that. And they've actually been saying that for a long period of time. So that's another important thing to remember. As far as committals are concerned, there is, I find quite handy, there's a 9-point checklist on all of the procedural things to remember. And it's in a case called Riel, in a judgment of Mrs. Justice Tice. And it's 2017, One Family Law Reports, 1135. If you find yourself on either side of a committal and you're looking at have all of the necessarily procedural requirements been followed through, or if you're looking to commit somebody, how do I make sure I don't get it wrong? That's actually a very succinct list. And if you follow that list, I don't think you can go far wrong. As far as enforcement is concerned, now, I think I have mixed views about enforcement, and I have plenty of times people come in front of me or contact has broken down and I want the other parent held to account. The difficulty with enforcement, because of the penal sanction, because of the rights to silence, is that sometimes that gets in the way of the questions that you want to ask. You want to say, look here, you've got to file a statement, I want to know all about this. Oh, I can't do that because somebody's threatening to send you to prison. Can you be asked to go and talk to CAFCAS all about it? No. Sometimes is a variation application, because that allows for a much broader welfare inquiry. However, I have a case that I've been involved in where I'm representing the Guardian for about the last 18 months, and it's been incredibly frustrating in that there are 4 children, 2 of whom are still having contact, or 2 of whom are having contact with their father, but it was almost as if they were aging out of contact. The father gave some evidence at a hearing where he was talking about some of the difficulties, and he just said, and then they were gone. It's just like that. His elder 2 children had gone from having contact to not. And we are tearing our hair out. How can we deal with this mother who's been given all of this advice by the judge, been told that no, this isn't going to, you can't say their wishes and feelings because you have the responsibility, and yet still these problems persisted. And in the end, the judge decided to bring committal proceedings of her own motion. And we had our hearing. She made all the findings. And then we decided that we would put off the question of sentence effectively to allow mother to purge her contempt. And it was set out very clearly that this is suspended on terms that you follow this order. Otherwise, we'll be back to sentence you next week. Otherwise, we're putting it off 3-4 months. There's a hearing, I think, in November to deal with it. I have not, since that hearing in July, heard a dicky bird to say that there is anything wrong with this contact. And before that, there was an email every week. What on earth are we going to do now? It is now, in this one particular case, fixed. So all of the things I've thought for many years, oh God, I'm not sure about this enforcement. What do I know? In the right case, it will work. So it's just the right remedy for the right case. And I think the final thing I wanted to say is that we've had a lot of case law. It's important to be aware of all of it, but there are no silver bullets. It's often about following the evidence, which takes us back to where we started with what Jennifer was saying, so that if you have an issue where there is alienation, that's telling me I need to get home. If you have an issue with alienation, don't just put that in your application, because we have, I think, on the bench, any kind of obstruction or difficulty, that's always what people are saying. You see it all the time. Focus on what it is that you are talking about. Is it that there is a concern that the child is being briefed and influenced? Is it that the child hasn't got emotional permission to go? Is it that the parent is letting their views about the other parent get the better of them? The more precisely it's set out, the more likely it is the judge is going to say, yes, this is a real issue. It's not just another case where someone's gone, oh, I'm not having contact, I'm going to write down alienation on here. Follow the evidence, focus less on the labels. Any questions that anybody has for us at this stage? Obviously, yeah.
Thanks for that. I have a case where, and I guess the question I'm going to ask is about how far we can push this to make sure the child is available for contact. Because I have a case where the child is now resorting to self-harming, using throwing himself in objects or running into traffic to avoid going into the contact centre. But mum is now doing everything she can, and no matter which way the court land on parental alienation, what's happened has happened now, and the child has these wishes and feelings. But mum is doing her part now to repeatedly take the child to the contact centre, but it's evidently causing emotional harm to the child. So in those situations, how far can we push this, make sure that the child is available, make sure the child attends contact in this way?
Thoughts?
How old is the child and have they had any therapy?
9 was referred to CAMS. CAMS said that wasn't suitable. And the next step is to explore private paying therapy, which then becomes the challenge because either parent says they can't afford to.
Is it a legal aid? Private or
Yeah.
And is it a question of could benefit from the therapy but doesn't meet the CAMS threshold?
Yeah.
What about ICFA?
The CAFCAS author that did the Section 7 report didn't recommend, which is a bit of a weird one, but then they invited NIAS on board to work with the child. But there's now a global family assessment.
Who's saying for that?
It's going to be a joint instruction, but father to pay lesser. Aid. But yeah, it's really challenging because even if she has presented these behaviours in the past, at the point that she is now trying and the child has made their mind up, you're still wary of that criticism being made against mum.
I mean, for my part, I think one of the things that was said, I think you said it, Stephen, that about time, obviously the longer it goes on, harder it gets, and that is a problem. The advantage of some with ICFA is in some of the preparatory work that they can do. So it used to be the old formulation is CAFCAS would provide the 12 hours under a child contact intervention. That was mainly for contact, that was it. The theory is that ICFA can be bespoke in terms of how much work and in terms of how much preparation and support could be offered. The only other thing that occurs to me is trying to look at different kind of venue. If there was a way of somewhere, I mean, it's difficult, isn't it? Because on the one hand, if it's an activity that the child enjoys, a place they enjoy going, that might be somewhere they might respond more positively to. On the other hand, you don't want a place they enjoy going to then to lose that. So it's difficult, but all about practical. I think that's and certainly I think ICFA. Yeah, Steve.
Yeah, I mean, the only two things that come to my mind is global family assessment is not direct work, it's an assessment. What you need is an expert to undertake direct work, that's therapeutic work, that has a sort of theraplay approach. And it's not a very attractive argument, but I've had so many clients that, yes, they're on legal aid, but if it was something else, they would find the money, or they can beg, borrow, steal the money. And this is their relationship with their child. If not, it's death equivalent. So they need to beg, borrow, steal that money, take a personal loan, get the proper expert, as if they were privately paying, and then put forward that direct work. And my other question was, what's the quality of the contact once the 9-year-old is in the space with the parent?
He's refusing to enter the space at all. They don't make it out of the car park. Yeah.
Well, Ed's point then about the correct activity, but yeah.
Yeah, I mean, you just keep trying to change the paradigm so that try and remove the pinch point, but it isn't always that's the thing.
Ms. Campbell has a question.
I was thinking is that, say if you were at enforcement proceedings and it may be that a parent's got to do the community service, etc., could you use that period of time to give and work for the other parent's contact?
Well, it could be.
I'm just thinking out because that's a good way to concentrate the mind of the parent that doesn't want to give the contact. Just throwing it out.
Well, I mean, creative solutions are often
Outside the box.
the nature of the beast. So yeah, no, we could do. Can I ask this? Because I was going to ask a couple of questions of all of you. I mean, I assume that many of you have had involvement in alienation cases. And I guess the first question is, how many of you, I mean, maybe if we can have a show of hands, how many of you have represented parents who are accused of alienation as opposed to, okay. And how many are you representing the parent from whom the child has been alienated? So there's similar figures. So, I mean, it's one of the reasons why it's quite important, I think, that we had a little bit, I think, in Jennifer's talk about kind of almost what's the differential diagnosis, because we do need to look at it both ways. Often there's something that's happened in the past between the parents, and often the alienation cases are more where it's thought of that that's past, and then something maybe much more minor has stopped, and then because contact was happening, and then it's fallen away. But it is important, I think, to look at that differential diagnosis. It's important to look at 12J. What about where are my questions I was going to ask you? I've lost. So how many of you in these difficult cases did contact eventually resume? Your hands. So a few. How many where it didn't resume? Similar number. People got experience of let's go to therapy, the court has effectively run out of road? Yeah, a little bit. Yeah.
They don't want to pay for it.
Okay. Well,
not the parents, even.
No. Well,
Authority, they don't want to pay for it.
No, they often don't. Those of you that have had this therapy angle, did you have any confidence that would work? Or don't know? You do. Okay, interesting. Anybody have any experience of changes of residence that happening in your cases? Okay. Interesting. I mean, I've had two recent cases that have come before me, and one of them I did order change of residence, and in the other one I didn't. And it's right what's said about it's not thought of as a last resort. That kind of gloss, the welfare checklist, that has gone. But it's still about balancing harms. It's probably, I mean, I don't know what your experience was, but it's not something that judges do lightly, or even happily, because you have attachments to one parent. Often it may involve a change of social support network, change of school, all the sorts of things, particularly as we're talking about older children, sometimes teenagers. And certainly in the case where I did it, it was a question of really I felt that the parent hadn't given me any option. I think she'd stopped contact. This is the fourth occasion she'd stopped contact, all for significant periods of time. Hadn't engaged with the proceedings, turned up on the morning of the final hearing, but hadn't engaged with the proceedings for 4 months. Only started engaging with any professionals when the local authority brought a child protection plan. Social worker had arranged to contact child when overjoyed to see the father. Next time somebody goes to see the child, oh no, I just want daddy to leave us alone. And the child turned up at school on the morning of the final hearing in a terrible, terrible state because his mum had said goodbye to him and that he was going to live with his father now. And so it really was pretty extreme stuff. And the only way to guarantee this child's emotional safety really was to say, well, tonight he's going to go home with his dad and we need to have a hearing about this tomorrow. And I did make that change. The other case where we had involvement, slightly older children, we had involvement of guardian, we had involvement of oncologist, was very clear evidence that changing the residence where the children were very attached to their mother and had were dubious, should we say, about their father, where some contact was starting to happen, but that would be harmful and more likely to lead the children losing the relationships with both of their parents. So we didn't do it. But that's just perhaps a little pen picture of when you might and when you might not. And in both of those decisions, what did I do? I followed the evidence. So that's often what it's all about. Okay. Anything else, or should we go downstairs and have a drink? One more. Okay, last one.
A few, I work for the local authority in Hertfordshire. I don't really recognise any faces, so you must all work it. But we have a very close relationship with Watford and the judiciary there. And I don't know what chicken or the egg, really. We put ourselves into a situation, and I think it is actually really very helpful, and, take this, is that often the court approaches us for confidential letters of involvement before even, maybe not before the first hearing, but very early on in the proceedings. And like I said, I don't know whether it was some clever lawyer or barrister that asked for it and the judge thought, gosh, that was helpful, or whichever way around it happened. But it does really help in terms of giving the court a very early view, if there has been local authority involvement, what that has involved. It will list, obviously, I mean, it's a summary, it's not a report, but summaries of there have been allegations of domestic abuse, or there have been, X, Y's and Z's. We've completed 2 or 5 CNF assessments and they are available for disclosure. And just as a point of practice, I think, often the letter initially just goes to the judge, and then there's a discussion about whether or not it is shared, because depending on what it contains. But that could be something that's very helpful for one or other of the parties, just to, as you say, about the early disclosure and getting your evidence in early and stuff like that, and very helpful for the judge to have that view almost before the evidence is put to them. They've kind of had an independent snapshot.
Yeah, I think Judge Brexter and his team at Watford are very good in terms of making administrative directions so that you've got information before you get to hearings. Perhaps the learning for us practitioners is sometimes if there is a reason for an urgent hearing to be listed in respect of any application, it can be something to request if there's been local authority information, because it's a way of getting better and fuller information before the court than if you simply wait for safeguarding. So yeah, that's a good tip. Thank you. Anything else, or should we have a glass of wine?
And I just have 2 quick things, and it's from listening to all of you, in fact. So tomorrow, in my case, the expert's not considering CBT and wants it to be cognitive analytic therapy for the thing that's specific to that. Let's say we all discovered the right terminology for the type of therapeutic intervention that was needed for these children, needed for the alienating parent. But the cost is the problem. With local authorities, you have trainee social workers sometimes doing very serious co-working a case, but sometimes doing serious work. And just listening to everyone, I wondered, and I'm just floating it so we can discuss it downstairs, is there a mechanism where we can go to reputable organizations that train therapists in the type of work that would be the applicable work to this sort of case, but as part of their training, they need to do a certain amount of hours, they won't charge for it. Is that a potential avenue for us to get some of this work in? Although I understand by putting this forward, it's not a resource where the person is fully qualified, but perhaps it touches at the issues in a way that's financially available. That's my first point. My second point is DDJ Elliott, and having his view from his professional experience has been amazing. Can we clap for him, please?